Hello and welcome to today's episode, which explains export payment terms including letter of credit and their operations. The term export means shipping in the goods and services out of the jurisdiction of a country. The seller of such goods and services is referred to as an exporter and is based in the country of export, whereas the overseas based buyer is referred to as importer. Students, let's discuss the key points of our course. First, international trade presents a spectrum of risk which causes uncertainty over the timing of payments between the exporter, seller and the importer, foreign buyer. Second, for exporters, any sale is a gift until payment is received. Third, therefore, exporters want to receive payments as soon as possible, preferably as soon as an order is placed or before the goods are sent to the importer. Fourth, for importers, any payment is a donation until the goods are received. Fifth, therefore, importers want to receive the goods as soon as possible, but to delay payments as long as possible, preferably until after the goods are resold to generate enough income to pay the exporter. Before moving to details of today's topic, let me give you a quick introduction about myself. I am Ms. Pallavi Mohan, working since 17 plus years, both nationally and internationally. Have worked in 5 countries and studied in 3 countries. Have held leadership positions in the field of marketing, retail, operations, PR and communication. Recent assignment was with Samsung Electronics as corporate communication professional, contributing towards 4 countries. Well, let's get back with the details of today's topic. Methods of payment in international trade. To succeed in today's global marketplace and win sales against foreign competitors, exporters must offer their consumers attractive sales terms supported by the appropriate payment methods. Because getting paid in full and on time is the ultimate goal for each exporter sale, an appropriate payment method must be chosen carefully to minimize the payment risk while also accommodating the needs of the buyer. There are 5 primary methods of the payment for international transactions. First, cash in advance. With cash in advance, payment terms an exporter can avoid credit risk because payment is received before the ownership of the goods is transferred. For international sales, wire transfer and credit cards are the most commonly used cash in advance options available to exporters. With the advancement of the internet, escrow services are becoming another cash in advance option for smaller exporter transactions. However, requiring payments in advance is the least attractive option for the buyer because it creates unfavorable cash flow. Foreign buyers are also concerned that the goods may not be sent if payment is made in advance. Thus, exporters who insist on this payment method as their sole manner of doing business may lose to competitors who offer more attractive payment terms. Second, letters of credit. Letters of credits are one of the most secure instruments available to international traders. An LC is a commitment by a company, a bank, on behalf of a buyer that payment will be made to the exporter, provided that the terms and conditions stated in the LC have been met, as verified through the presentation of all required documents. The buyer establishes credit and pays his or her bank to render this service. An LC is useful when relying credit information about a foreign buyer is difficult to obtain, but the exporter is satisfied with the creditworthiness of the buyer's foreign bank. An LC also protects the buyers since no payment obligation arises until the goods have been shipped as promised. Third, documentary collection. A documentary collection is a transaction whereby the exporter entrusts the collection of the payment for a sale to its bank, which sends the documents that its buyers need to the importer's bank with instructions to release the documents to the buyer for payment. Funds are received from the importer and remitted to the exporter through the banks involved in the collection in exchange for those documents. DCs involving using a draft that requires the importer to pay the face amount either at sight or specified date. The collection letter gives instructions that specify the document required for the transfer of title to the goods. Although banks do act as facilitators for their client, DC offers no verification process and limited resource in the event of non-payment. DCs are generally less expensive than LCs. Fourth, open account. An open account transaction is a sale where the goods are shipped and delivered before payment is due, which in an international sale is typically in 30, 60 or 90 days. Obviously, this is one of the most advantageous option to the importer in terms of cash flow and costs, but it is consequently one of the highest risk options for an exporter. Because of an intense competition in export markets, foreign buyers often express exports for open account terms since the extension of a credit by the seller to the buyer is more common abroad. Therefore, exporters who are reluctant to the extend credit may lose a sale to their competitors. Exporters can offer competitive open account terms while substantially mitigating the risk of non-payment by using one or more of the appropriate trade financing techniques covered later in this guide. When offering open account terms, the exporter can see extra protection using export credit insurance. Fifth, consignment. Consignment is international trade, is variation of open account in which payment is sent to the exporter only after the goods have been sold by the foreign distributor to the end customer. An international consignment transaction is based on a contractual arrangement in which the foreign distributor receives, manages and sells the goods for the exporter, who retains title to the goods until they are sold. Clearly, exporting on consignment is very risky as the exporter is not guaranteed any payment and its goods are in a foreign country in the hands of an independent distributor or agent. Consignment help exporters become more competitive on the basis of better availability and faster delivery of goods. Selling on consignment can also help exporters reduce the direct cost of storing and managing inventory. The key to success in exporting on consignment is to partner with a reputable and trustworthy foreign distributor or a third-party logistics provider. Appropriate insurance should be in place to cover consigned goods in transit in possession of a foreign distributor as well as to mitigate the risk of non-payment. A letter of credit is a document issued by a third party that guarantees payment for goods or services when the seller provides acceptable documents. Letters of credits are usually issued by banks or another financial institutions, but some credit-worthy financial services companies like insurance company or mutual funds might issue letter of credit under certain circumstances. A letter of credit generally has three participants. First, there is a beneficiary, the person or company who will be paid. Next, there is a buyer or applicant of goods or services. This is the one who needs the letter of credit. Finally, there is a issuing bank, the institution issuing the letter of credit. In addition, the beneficiary may request payment to an advising bank, which is a bank where the beneficiary is a client. This might be done, for example, if the advertising bank financed the transaction for the beneficiary until payment was received. Letters of credit are most often used in international trade, where they are governed by the uniform customs and the practices for documentary credits, the rule of International Chamber of Commerce. However, they can be used in other situations, as we shall see. Types of features of letter of credit. Most letter of credits are import-export letters of credit, which, as the name implies, are letters of credit that are used in international trade. The same letter of credit would be termed an import letter of credit by the importer and an exporter letter of credit by the exporter. In most cases, the importer is a buyer and the exporter is a beneficiary. There are also other types of letter of credit. The revocable letter of credit can be changed at any time by either the buyer or the issuing bank with no notification to the beneficiary. The most recent version of the UCP 600 did away with this form of letter of credit for any transaction under their jurisdiction. Conversely, the irrevocable letter of credit only allows change or cancellation of the letter of credit by issuing bank after application of the buyer and approval by the beneficiary. All letters of credit governing by the current UCP are irrevocable letter of credit. A confirmed letter of credit is one where a second bank agrees to pay the letter of credit at the request of the issuing bank. While not usually required by law, an issuing bank might be required by court order to only issue confirmed letter of credit if they are in receivership. As you might guess, an unconfirmed letter of credit is guaranteed only by the issuing bank. This is the most common form of regard to confirmation. A letter of credit may also be a transferable letter of credit. These are commonly used when the beneficiary is simply an intermediary for the real supplier of the goods and services or is one of the group of the suppliers. It allows the named beneficiary to the present its own documentation but transfer all or part of the payments to the actual suppliers. As you might guess, an untransferable letter of credit does not allow transfer of payments to third parties. A letter of credit may also be at sight, which is payable as soon as documentation has been presented and verified, or payment may be deferred. Deferred letter of credit may be put off until a certain time period has passed or the buyer had the opportunity to inspect or even sell the related goods. A red clause letter of credit allows the beneficiary to receive partial payments before shipping the products or performing the services. Originally, these terms were written in red ink, hence the name. In particular use, issuing banks will rarely offer these terms unless the beneficiary is very creditworthy or an advising bank agrees to refund the money if the shipment is not made. Finally, a back-to-back letter of credit is used in a trade involving an intermediary such as trading house. It is actually made up of two letters of credits, one issued by the buyer banks to the intermediary and other issued by the intermediary's bank to the seller. Documentation required. In order to receive payments, the beneficiary must present documentation of completion of their part in the transaction to the issuing bank. The documents that the issuing bank will accept are specified in the letter of credit, but may often include bill of exchange, invoice, government documents such as license, certificates of origin, inspection certificates, embassy legalization, and phytosanitary certificates, shipping and transport documents such as airway bills, insurance policies or certificates, except cover notes. Risk in letters of credit transactions. Letter of credit transactions are not without risk. The risk inherent in these types of transactions include fraud risk, in which the payment is obtained through the use of falsified or forged documents for worthless or non-existent merchandise; regulatory risk, in which government action may prevent completion of the transaction; legal risk, in which legal action prevents completion of the transaction; force majeure risk, in which completion of transaction is prevented by an external force such as war or natural disaster; failure of the issuing or collecting bank, or insolvency of the buyer or beneficiary. In addition, the normal risk inheritance in transactions such as non-delivery, shipping, less than ordered, inferior quality merchandise, early or late shipment, or goods being damaged in the transit apply. Documents that can be presented for payments. To receive payments, an exporter or shipper must present the documents required by the LC. Typically, the payee presents a document providing the goods were sent instead of showing the actual goods. The original bill of lading is normally the document accepted by the banks as proof that goods have been shipped. However, the list and form of documents is open to the negotiation and might be containing required to present documents issued by a neutral third party evidencing the quality of the goods shipped or their place of origin or place. Typical types of documents in such contract include financial documents, bill of exchange, co-accepted draft, commercial documents, invoicing, packing list, shipping documents, transport documents, insurance certificates, commercial, official or legal documents. Official documents license, embassy legalization, origin certificates, inspection certificates, phytosanitary certificates, transport documents, bill of lading, ocean or multimodal or charter party, airway bills, lorry, truck receipts, railway receipts, CMC other than mate receipts, forwarder cargo receipts, insurance documents, insurance policy or certificate but not a cover note. If import machinery device, then required test certificates. Legal principles governing documentary credits. One of the primary peculiarities of the documentary credit is that the payment obligation is independent from the underlying contract of sale or any other contract in the transaction. Thus, the bank's obligation is defined by the terms of the LC alone and the sale contract is irrelevant. The defenses available to the buyer arising out of the sale contract do not concern the bank and in no way affect its liability. Article 4A of the UCP 600 states this principle clearly. Fundamental to all letter of credit is the principle that letter of credit deals with documents, not with goods. Article 5 of the UCP 600 explicitly states that banks deal with documents only. They are not concerned with the goods, facts. Accordingly, with the documents tendered by the beneficiary or his or her agent are in order, then in general the bank is obliged to pay without further qualification. Therefore, the buyer bears the risk that a dishonest seller may present documents which comply with the letter of credit and received payments, only to the later discover documents are fraudulent. The policies behind adopting the abstraction principles are purely commercial and reflect a party's expectation. First, if the responsibility of the validity of documents was thrown onto banks, they would be burdened with investigation, the underlying facts of each transaction, and less inclined to issue documentary credits because of the risk and inconvenience. Second, documents required under the LC could be certain circumstances to differ from those required under the sale transaction. This would place banks in a dilemma in deciding which term to follow if required to look behind the credit agreement. Third, the fact that the basic function of the credit is to provide a seller with the certainty of payment for documentary duties suggests that banks should honor their obligation, notwithstanding allegation of buyer misfeasance. Courts have emphasized that buyers always have a remedy of an action upon the contract of sale, and it would be calamity for the business world if a bank had to investigate every breach of contract. The principle of strict companies also aims to make the bank's duty of effecting payment against documents easy, efficient, and quick. Hence, if the documents tendered under the credit deviate from the language of the credit, the bank is entitled to withhold payment, even if the deviation is purely terminological. Legal basis. Legal writers have failed to satisfactorily reconcile the bank's undertaking with any contractual analysis. The theories include the implied promise, assignment theory, the novation theory, reliance theory, agency theories, estoppels and trust theories, anticipatory theory, and the guarantee theory. Although documentary credits are enforceable once communicated to the beneficiary, it is difficult to show any consideration given by the beneficiary to the banker prior to the tender of documents. In such transactions, the undertaking by the beneficiary to deliver the goods to the applicant is not sufficient consideration for the bank's promise, because the contract of the sale is made before the issuance of the credit. Thus, consideration in these circumstances is past. However, the performance of an existing duty under a contract may be valid consideration for a new promise made by the bank, provided that there is some practical benefit to the bank. A promise to perform owned to a third party may also constitute a valid consideration. Another theory asserts that it is feasible to typify letter of credit as a collateral contract for a third-party beneficiary because three differentiates entities participate in the transaction: the seller, the buyer, and the banker. Because letters of credit are prompted by the buyer's necessity and in application of the theory of Jean Domate, the cause of a LC is to release the buyer of his obligation to pay directly to the seller. Therefore, an LC theoretically fits as a collateral contract accepted by conduct, or in other words, an implied in fact contract under the framework for third-party beneficiary, where the buyer participates as the third-party beneficiary with the bank acting as the stipulator and the seller as the promisor. The term beneficiary is not used properly in the scheme of an LC because a beneficiary in the broad sense is natural person or another legal entity who receives money or other benefits from a benefactor. Note that under the scheme of letter of credit, banks are neither benefactors of sellers nor benefactors of buyers, and the sellers receive no money in gratuity mode. As a result, this kind of arrangement would make letter of credit to be enforceable under the action exempted because of its promissory connotation. A few countries have created statutes in relation to letters of credit. For example, most jurisdictions in United States have adopted Article 5 of the Uniform Commercial Code. These statutes are designed to work with the rules of practice, including UCP and ISP 98. These rules of practice are incorporated in the transaction by agreement of the parties. The latest version of the UCP is UCP 600, effective July 1, 2007. Since the UCP are not laws, parties have to include them into their arrangements as normal contractual provisions. International Trade Payment Methods documentary credits, more secure for seller as well as buyer, subject to ICC UCP 600. The bank gives an undertaking on behalf of the buyer and the request of applicant to pay the beneficiary the value of goods shipped if acceptable documents are submitted and if stipulated terms and conditions are strictly complied with. The buyer can be confident that the good he is expecting only will be received, since it will be evidence in the form of certain documents called for meeting the specified terms and conditions, while the supplier can be confident that if he meets the stipulations, his payments for the shipment is guaranteed by the bank, who is independent of the parties to the contract. Documentary collection, more secure for buyers and to certain extent to sellers, also called cash agents documents, subject to ICC URC 525, site for delivery of shipping documents against payment or acceptance of drafts. Where shipment happens first, then the title documents are sent to the buyer's bank by seller's bank for delivering documents against collection of payments acceptance. Direct payment, most secure for buyers. The supplier ships the goods and waits for the buyer to remit the bill on open account terms. These were the international trade payment methods. Also, we have come to the end of this session of the topic export payment terms, including letter of credit and their operations and details associated with it. That is all for today. Hope you have understood. We'll see you again with the next topic. Till then, take care. Bye.